This meeting is now being recorded.
Welcome, everybody. It's a pleasure to join with all of you, especially on the eve of a long weekend. This is Ren Hayhurst at Bryan Cave, and we have multiple members of the First Bank team that are local here in Irvine joining us, as well as many of our Bryan Cave lawyers. One of the things that I wanted to indicate up front before I turn over a moment to Peter to make formal introductions and get us started is that this program, although it deals with the issues of subordinations, tri-parties, and other similar type agreements, we definitely will spend a lot of time bouncing back and forth between both real estate-related issues as well as non-real estate-related issues. And we'll be sharing stories and examples for both commercial loans, C&I loans, working capital lines, revolving lines, as well as different forms of real estate secured loans. So we're going to do all of that, and we're going to do it in 60 minutes, and we're not going to hold people up. So with that, I'm going to turn it over to Peter for a more formal introduction, and we will get off and running.
Thanks, Ren. I just wanted to thank Ren and Bryan Cave for, again, putting these sessions on for us. I think they've been informative over the last few years since Ren has so graciously volunteered his time. Right now, based on RSVPs, we have close to 100 people on the First Bank side, so it's great to see that level of participation. And for those of you, we've got a lot of new personnel in the lending groups, so I wanted to give a brief introduction of Ren's background. He does both real estate and C&I lending. He's officed in the Irvine office of Bryan Cave. What is interesting about Ren, well, there's several interesting things about Ren, but one particular interesting thing is that he started off as a trial lawyer when he first started his career, and I believe that always lends a lot of value to a transactional lawyer to know exactly how to draft a document to avoid what can go wrong, and it's good to have that background. So with that, Ren, I will turn it over to you, and thank you again for your time and effort for us.
Well, thank you, Peter, and it's certainly our pleasure because with these programs, for us, it accomplishes three things. One is we love this bank. Our firm has a long established relationship with this bank, and we feel very proprietary towards this bank. We love to see your success. We love to see your achievements, and we love to be part of those when it's appropriate. Number two, this is always a good opportunity for us internally to refresh ourselves and to share examples. And when we put together these programs, we do it as a group, and I poll people for different situations. I draw examples from different deals, and it's a way for us to update ourselves, provide continuing legal education both for our teams as well as for your team. So, again, I would remind, to the extent there are First Bank lawyers on the phone, if you coordinate with Rachel Muntz, she will make sure that she gets all of your CLE materials to you so that you can get your proper credit. She's gotten that all arranged for us, and I'm very grateful to her for that. The final thing is this gives us an opportunity to share with you the way that we look at your business. Because, as Peter mentioned, I came from a litigation background, and so I came from a background where initially my job was to review documents from somebody who drafted documents that I was sure, A, did not really understand the underlying business that they were trying to document around, and more importantly, they gave no thought to what would happen if things went wrong. And our focus is to both know your business, hopefully as well as you do, and everybody that we've ever worked with at the bank has been very generous in sharing your knowledge so that we can become up to speed and become knowledgeable in your business. but we want to be business facilitators. We want to be able to assist you to not only help bring business in by thinking it through on the front end, but when we do get a chance to work with you, we definitely want your customers to feel like they've had a great experience, notwithstanding the fact they're paying our bill. We want them to feel that they've gotten value and that they would like to do more business with First Bank. And that to us is the measure of whether or not we've done a good job. The final thing that is important is most of the issues that we're going to talk about, and it's particularly true in this area, is I tend to look for patterns and I tend to look for concepts, because I think concepts lend themselves well to finding solutions. And we're deal makers, and I know you're deal makers. And so we want to combine with you to find solutions. If we understand the concepts, when somebody on the other side raises an issue or raises a difficulty, if we understand the business well enough, if we understand your internal underwriting criteria, we can successfully be able to craft within the concept a resolution. So I will spend some time sharing with you the conceptual ideas around these types of documents, but I promise you this. At the back of the booklet of the materials that you have, there is a primer or a white paper that's about 5 pages long. And it is the heart and soul and the guts of a checklist or a cheat sheet that you would want to have as a guidance, whether you're doing a real estate junior loan or a mezzanine loan secured by a pledge of a partnership interest, or even an unsecured loan that we very often see in commercial deals, where you may have shareholder loans to the company, you may have investor loans. We've even done deals with charitable institutions where different investors in the institution have chosen to give both charitable contributions and make loans to the charitable entity, and hence they require some attention by the senior lender, which First Bank always finds itself in. So you do have some very specifics with detailed lists of items that are must-have items, some very specific examples of language we use. So this isn't going to be all 30,000 feet. There's a lot of cheat sheet material which we hope will be helpful to you going forward. With that, let me start off and go through our slides and talk a little bit about what we're going to be trying to accomplish. So when we approach reviewing a situation where there's going to be some other debt that affects your borrower, and that debt could be in the nature of a junior real estate lien, it could be a mezzanine loan from a hard money lender, it very often could be an investor who is making a capital loan or is making a capital investment, which has a lot of controls and a lot of bells and whistles that sure enough look and act like a loan. And those are often buried deep in the organizational documents, but when we read through them, in our minds we say, this is really debt. It's not acting as equity. And it's expecting to be treated as debt and to give rights as debt. So we look at those items. We're also going to spend a little time talking about ground leases and other types of leases and S&DAs, as well as property-related restrictions, rights of first refusal, purchase options, rights to expand. I know that I've done deals with this bank where the primary thrust of the deal is clearly a working capital line. We've taken a combination of collateral that is real estate collateral as well as personal property collateral, and probably the personal property operational collateral is the most valuable, and it's the one that we focus on. Nonetheless, we need to be able to deal with, in that mixed collateral package, the best way to deal with, in some cases, we've had insider loans as well as third-party loans that needed to be addressed, because the number one guiding principle is the senior lender gets first, dollars out. And we want to protect that. And there are ways that people disguise how they can perhaps get distributions or use funds, taking monies by the way of development fees, etc., management fees, operational fees. We see it in a whole bunch of contexts, but bottom line, it's a way where they're trying to take income from the property or income from the business that you're loaning before you, the lender, gets paid in full. And that's where we focus our energies on. Finally, we will spend a little bit of time talking about some development restrictions. And this comes into play even if you're not making a real estate loan. You can be making a working capital loan. We did a working capital loan for a coffee company, and we chose not to take a lien on their manufacturing plant. But they had all kinds of rights to that manufacturing plant, rights where competitors could have theoretically bought the plant out from under them, and then where would we be in terms of a source of repayment? So we had to address that, even though it wasn't a real estate loan, because we wanted to protect the ongoing business operations. And so we had to look at the real estate, and we had to look at some of the controls and some of the limitations that were on the real estate. So we will spend some time talking about those items. I keep pushing the wrong button to advance the slides, so here we go. The first thing I want to do is I do want to draw a distinction between secured and unsecured debt. Now, obviously, secured debt comes in a variety of forms. The most obvious is a junior lien on the real estate collateral that's owned by the company. It also can come in the form of a pledge of the ownership interest in the company, or perhaps a second-tier pledge, maybe the pledge of the development entity or the investor entity. We're doing a deal right now where we represent a 60% owner of a condo project in Florida. Actually, we represent the mezz lender. They're taking a pledge of that 60% interest. And if they were to foreclose, they're subject to all types of restrictions vis-a-vis the developer. And we want to make sure we have a smooth transition if we have to step into those shoes, and that we have a smooth relationship with that development entity, because this condo project, if it sells out and it's 83% pre-sold with 40% deposits on hand, it's a $550 million project. So there's a lot of money to protect, and there's a lot of interest that we have in making sure that they can step into the role they anticipate. But the other type of debt you'll see is unsecured debt. And I do want to highlight for you, you'll see that in two different forms. One is going to be very often with the companies, and I know that John has seen this and others of you have seen this in your commercial loans. You see company loans made by the founders, made by investors in the company, and they choose to contribute to the company in the form of debt as opposed to equity. And in that instance, there are going to be two things we'll want to see. It's best if we see some evidence of the debt. Very often these things do happen on handshakes. And I'm sure you guys have all seen situations where, yes, the president of the company invested $500,000, but you know what? I don't think we ever drafted a note. Some of those things we want to make sure that they clean up for their protection, but also for our protection. That's number one. Number two, you will see, and I was speaking to Kameo, one of our associates this morning, we were talking about the way that more and more we're finding this kind of insider unsecured debt not being in the usual places, meaning debt that you would show on a balance sheet that you could trace to some kind of note or some kind of relationship, but rather it is insinuated and built into the organizational documents of the entity. And very often we're seeing that investors are making their capital contributions, but the rights that they give themselves within the company walk and talk like debt. They have the right to take control. They have a right to effectively foreclose by pushing out the development partner or the operational partner. They have the right to claim preferred distributions from the company. And all of those things are potential threats to your underwriting, because you're assuming, again, that after the operating expenses are paid, first dollars go to pay senior debt, not to pay insiders. So we want to be very careful to find those, and I must say that where maybe 10 years ago this was the exception to the rule, it's certainly something that we see at least 50% of the time. And it is clearly an effort to disguise their debt. It's clearly an effort to not have the bank pay attention or impose any type of restrictions. And we have all kinds of devices, and we'll talk about how to deal with that. This does not have to be a difficult or a painful process, but we do want to talk about the importance of addressing that up front. On lien subordinations, the one thing I do want to emphasize is we use the word subordination pretty loosely in this realm. There's no magic to the term subordination. So in other words, very often we'll call our documents tri-party agreements. We'll call them intercreditor agreements. We'll call them recognition agreements. Because very often, as I'll talk about in just a moment, our main focus is establishing a relationship with that other investor so that we can coexist peacefully. Now, that doesn't necessarily sound like a subordination. A subordination has with it junior lender, you have no rights, you can take no action, you wait until we're paid first, and then you're allowed to proceed forward. Now, there may be instances that those are the rights that you want, and we're happy to go ahead and get those rights. But more times than not, in any type of debt situation, secured or unsecured, we're looking at three things. And this applies to leases, ground leases, as well as to debt. And if you take nothing away from this seminar, I would like you to have planted in your mind this concept. A well-drafted tri-party subordination intercreditor agreement anticipates three things, three relationships. The first relationship is the relationship between the parties, meaning senior lender, borrower, and other investor/lender. What is your relationship when everybody is behaving? Who has what rights? Who has what obligations? Who's held harmless? Who is not looked to as a source of being a problem solver? What is the relationship when everything is functioning the way that it should be? And what rights do you have as the senior lender to make sure that the status quo that you've underwritten stays the same? So things like transfers of ownership interests, assignments of rights, modifications of junior financing, All of those things are things that you're concerned about because you want to preserve the relationship in a way that reflects what you underwrote at the outset. So I want you to think about that pre-default, everything is going good relationship. The next relationship that you should focus on is there is a default. There's a default either under your senior loan or there's a default under the junior financing. And that, again, can be buried in the operating agreement, which triggers some rights of the investor to start taking and asserting some control aspects, some management aspects, and controls over your borrower that you don't necessarily think may be the right thing. Or at least, at the very least, you want to make sure that you're in the loop and that you have approval rights. Because here's the guiding light for me. I know that auditors do not expect your loan, when you make them, to have pre-established loan workouts built into them. And so silence is a workout by de facto, right? The other side does what they want, and you're stuck with the consequences, and you have to react to it. That is a de facto workout. The other is where you have some rights either to intervene or to impose a standstill for a limited period of time, or to be involved in discussions, or to be able to assert your senior rights to protect your interest in exercising on your collateral so that you maintain the types of control that you want. And so, giving you that discretion, which discretion should arise at the time of the problem, should not be resolved up front, is not a pre-approved workout. And we want to protect you from that because we have seen lenders get dinged on their audit for basically trying to overthink and build in pre-approved workouts. So we want to give the best of both worlds. We want to create a structure whereby the parties can work out a solution and where you can have some control over that solution, but you're not stuck and you can apply your then current underwriting standards to reach the right result for you as the senior lender. So that's relationship number 2. And of course, relationship number 3 is all heck breaks loose. You have to exercise your remedy. You now become the owner of the asset, whether that is the real property or whether that is the ownership of the company. And what are you going to do with that? What type of indemnities do you expect? What type of exculpation from liabilities do you expect? But at that point, you are certainly looking to enter into an agreement which is bank-friendly, meaning you, if you are stuck in this position, you're not an operator. You're not looking to become an operator. What you want to do is be able to come in and make reasonable decisions to make the property or the asset, the company, saleable as soon as possible so that you can take those proceeds and repay your loan. And so we want to give you those protections during that third relationship. So that is, to me, the framework for any type of tri-party situation is to look at this conceptually as a 3-relationship item and how do you manage those relationships. Now, before I go into a little bit of specifics on lien subordinations and give you some cheat sheet items, I did get a text from my good friend, Mr. Kuselis, who's on the road in Boston, and he has, I think, a very good point to make about the concept of deep subordination and what that does or doesn't mean, because I think we've all heard that phrase, right? We want something deeply subordinated. So, Jimmy, I'm going to turn it over to you for just a couple of moments to talk about that concept.
Sure. Thank you, Ren. When I hear the concept of deep subordination, what it makes me really think of is there's no legal term of a deep subordination. To me, a deep subordination means how many of these different rights and restrictions do you put against the other party that's the party to the subordination agreement. So whether it's with respect to payments, there can be no payments at all during the term of the loan, or is it that there can be payments only when there's no default? When it comes to exercise of remedies, is it a complete prohibition of exercise of remedies, or is it an exercise of remedies only in certain circumstances? So it's a concept that I want people to be mindful of, because you'll hear people say, we want a deep subordination, and there is no legal concept of a deep subordination. It's really how many hammers do you put against the subordinate party, and what will you let that subordinate party do during those 3 periods that you mentioned earlier. So I wanted to throw that out there for everyone.
And I think that is a perfect segue for a laundry list that I'm going to give you on this slide, some key things to remember when you have a real estate deal. So in a real estate deal, what you will typically be faced with is the borrower and or the title company will come to you and say, go ahead and use our form of subordination agreement. Their form of subordination agreement looks really attractive to the borrower because it's 2 pages long. And that agreement does not address at all any of the 3 relationships we've talked about. It states the obvious. It states that your lien is senior to their lien, period. It does not create a cooperative relationship. It does not create an infrastructure for resolution of problems. It does not create an ability for you to, as Jim said, make selective decisions as to how you're going to manage these ongoing relationships. It is, in a word, worthless. So if you get thrown to you on a real estate deal, a title company subordination, you can be very polite and say thank you. You can forward it to us, and then we will all joyously burn it in the parking lot because it does not have any value. And the reason I would say that is in a lien subordination issue, the least important aspect is the subordinate piece. In most instances, your lien will be recorded first. So as a matter of title, it is senior, and they are subordinate. A piece of paper that repeats that is nothing. What you are looking for is a dynamic tri-party relationship. And as Jim said, the primary items that we want to address in this slide are payment rights. What are the payment rights that you will permit for the junior loan? Here's what's typical. If our loan is being paid, if our covenants are being met, then you are able to take your regularly scheduled payments under your debt that we have approved ahead of time, and you can accept those payments from what's left over. To the extent that the project lacks sufficient cash to make those payments, there's a standstill. You don't get to collect those anymore. They're not permitted payments. To the extent that the income is not sufficient to pay the senior debt, they certainly are not going to get paid before you are. and it's important for both secured or unsecured deals to have the concept of a standstill. And the standstill is when there are certain triggers, and those triggers are the items I just discussed. It can be based on a DSCR test. It can be based on a net worth or liquidity test. But when you've hit one of those triggers in your loan documents, secured or unsecured, you want to be able to alert your junior lender, you have no more rights to accept payments, number one. And number two, if you do accept payments hereafter, you are accepting them in trust to eventually turn over to us to be applied to the senior debt. And so that is an important concept. Where the art comes into is how long are you going to give this standstill? So that takes us to item number 2. One way of dealing with this, which is not really popular anymore, is the permanent standstill. Now, you can do this with insiders. I know, John, with the type of deals that you do, you have sophisticated insiders. If you tell those insiders, we've got a default or a breach under our agreement, and when that happens, you just can't take any money out of the company until we fix our problem. They're going to get that. They're going to understand, and they're going to agree to a permanent standstill. When you get a third-party investor who is making the debt, they don't see it the same way. They want some kind of predictability, some kind of time limit. So that takes us to what I call the first look standstill. And what the first look standstill is simply this. If we have one of these triggering events and they are no longer entitled to be able to receive their permitted payments, we are going to agree up front to a time period. That can be as short as 30 days. I don't like that answer. It can be as long as 180 days. They don't like that answer. So the standard seems to be in the industry 90 to 120 days. Now here's the great thing about a good standstill. A good standstill is not intended to simply hold them up so that you can build their army to crush your borrower and to crush the subordinate lender. A good standstill is intended to create and facilitate a conversation whereby you fix the problem. And very often, fixing the problem is having that junior investor come up with additional money that will have to be subordinated, but additional sources of funds to fix your problem and get your loan back on track. And so we always create what we call a first look standstill with 3 key components. Component number 1 is the timing. There will be a certain set of timing where the junior lender simply has their hands tied. The second aspect is the encouragement, covenant, and requirement that the parties are going to use that time period to meet and to discuss a resolution. We always want to help you find a way to help your borrowers or their investors fix their own problems. Your bank is not in the business of running companies. Your bank is not in the business of owning development property. Your bank makes loans. So to the extent that there is a threat to the repayment of the loan, we want to create an atmosphere that encourages and has us at the table for a resolution of how to keep your loan on track so that you can be repaid. So we want that standstill to have a very real purpose, and that purpose is to fix. The third item is that prior to the end of the standstill, we provide the ability for you, if things aren't getting worked out, to go ahead and commence your remedy. Because the first in line, first in right concept is very powerful. And if somebody needs to file a remedy, whether that's to go into court, whether that is to do a non-judicial notice, either for a UCC pledge or for a real estate financing pledge, we are absolutely committed to making sure that before the end of the standstill, you get that first bite of the apple before they can take any steps. That way, your lawsuit would control. If they file subsequently, they are going to be joined to your lawsuit. They're going to be the tail wagging the dog on your lawsuit, and you're going to control that piece of litigation. So we want to preserve that right for you in that situation. But unless you're dealing with true insiders, the idea of the permanent standstill just doesn't work. If you're dealing with third-party institutional investors, we do have to give thought to the standstill concept, and when we do, those are our three target items and the things that we protect. I gave you a quick list of primary items to subordinate. Certainly payment rights, we've talked about those. Remedies, we've talked about those. Modifications, additional advances, extensions, etc. Here's what we like to do. We like to say, you senior bank can do whatever the heck you want, and they're stuck with it, and they'll always be subordinate. But they can do nothing without your consent. That's not really the way it works in the real world. In the real world is we meet somewhere in the middle, and we agree on certain material modifications that require each side's consent. And those are the obvious ones. Neither side is going to increase their loan beyond the current debt limit. However, we carve out, particularly for you, the right to make protective advances. If you have to make a protective advance to protect your interest in the company, that is going to remain senior, and they're going to acknowledge that. Second is we don't want people to increase their interest rates, but again, we carve out your right to get default interest rates, late charges, etc., that are built into your documents. Third is we want to make sure that that we have subordinated your right to extend the loan without any restriction. And when you think about it, this is the easiest, because under most state law, if you, the senior lender, have a default and choose to do nothing, you stay senior. You don't lose your senior position. So if you have a de facto forbearance, you stay senior. So it's foolish for the other side to try to negotiate or limit your ability to extend. On the contrary, we don't want either side to accelerate, except in your case, the right to accelerate if there's been a default or a breach. We've got to protect that. We've got to protect your right to accelerate your debt. Finally, the item that is becoming increasingly important is the bankruptcy rights. And what we put in our subordinations, as well as our guarantee agreements, as well as our third-party agreements, we want the other party to acknowledge that if there is a bankruptcy, that you, senior lender have the right to make decisions for the borrower till you're paid in full. You have the right to vote the entire debt for both parties until your loan is paid in full. We do not want to have you be stuck into some kind of internecine battle between the lenders over who's voting which way. Because one of the risks in a bankruptcy is that the other lender tries to create and put themselves in a different class. And by doing that, they then have additional rights which could hold up the bankruptcy. So our bankruptcy provisions are extensive. We have them acknowledging that they are of the same class and that you have the right to vote their interest unless and until the deal has been worked out. I am happy to say that recently, meaning within the last 6 months, there have been 2 leading cases which indicate that in a subordination agreement where these bankruptcy rights are clearly spelled out, the bankruptcy court will fully enforce them in favor of the senior lender. So these are real. These will protect you, and they are enforceable. The key is we have to articulate them clearly. But if we do our job, you will have the protections that you expect in terms of controlling the bankruptcy process and making sure first dollars out come to you. Best example I can give you is a deal we did for a bank that went bankrupt in 2008. The bank didn't, the borrower did. Huge enterprise. We had UCC liens on a huge amount of equipment. We had real estate liens on vast tracts of property. A lot of this in the early stages of the bankruptcy was sold at fair market value, so we got proceeds paid to pay down our loan. But lo and behold, after some quiet, the trustee has been doing their job and has been going out and marketing and auctioning off this property. And a year ago, we got a notice from the trustee that we were going to be receiving $4 million for the efforts of them to sell the real estate property. This was manna from heaven. It was found money because we didn't know if that was ever going to be sold. But because of our senior rights that had been acknowledged by the bankruptcy court, the trustee was telling us, this money's coming to you 100%. So be ready for a big check. I just received a notice within this month that there is going to be a final distribution of about $2.5 million. By drafting these provisions correctly, we've grabbed $6.5 million on this credit line that we otherwise would not have gotten. So these provisions are real, they're enforceable, they make a difference. I'm going to screw up my slides here. I'm very sensitive in timing, so I'm going to go a little bit quickly here because I set up the whole structure of the way we think about things and talk about the concepts of our subordination or intercreditor agreements. Please note that we always look at these as tri-party agreements. We are building relationships with you and your borrower, relationships with the other party who holds debt. And we are looking to balance those relationships for your benefit, of course, first, but recognizing some of the realities, including creating the possibility of either the borrower or its investor bringing in extra money to help cure default and get your loan back online. So we do not want to discourage those efforts. We want to encourage them. We just want to make sure that we're in control of what they are so that they're not foolish or vain attempts. to try to save a sinking ship. We've talked about the role of permitted payments, the rights to take over entities. We've talked about standstills. The one thing I will say is if you have a real estate deal where it consists of partial releases, meaning it's going to be an industrial condo, it's going to be an office condo, it's going to be residential single-family homes that are going to be built. We always build into our subordination what I call the free release provision. And that basically says if a unit's ready to be sold and it meets the test of our senior loan, you junior lender are going to give your release even if you get nothing. Now, we're not trying to wipe out your debt. We, in fact, affirm and acknowledge the continuation of their debt. But their debt becomes unsecured at that point, and it becomes subordinated in every way possible, including in the bankruptcy forum, to our debt, because if there's money to be paid, it comes to you. And if there are insufficient funds to pay them on top of that, that's their problem to work out separate from this relationship. Because the last thing you want when you have one of these projects is something or someone preventing a sale. We do not want to lose that sales momentum. We do not want to lose the good buzz of having sales. And so we absolutely protect that right with the free release provisions. We've talked about changes. Here's a little something that I put in. I used to put this in our form as an option. I now put in as a de rigueur provision, meaning it comes in every time. And that is, I give anybody, your borrower, the third-party lender, a new investor, the right to come in and buy your loan and take you out. Now, when we say buy your loan, we define par as being your principal, your interest, your default interest, your late charges, your foreclosure fees, and your attorney's fees. But if somebody wants to step up and buy your loan, as is, where is, no warranties, no indemnities, no promises, I think you should sell it every time and get the heck out of town. So I put that in now as an absolute and give that right to repurchase your loan and let you out of the deal because we also build in these other protections where there won't be any trailing liabilities. We've talked about protective advances and we've talked about bankruptcy rights. So moving here forward, some areas of concern. Again, I think we've covered certainly the free release and the bankruptcy issues. Here's what I'd say. We are always very, very sensitive to cross-default and cross-collateralization provisions. We definitely want to make sure that your junior lender is not cross-defaulting their debt with some other relationship they have with the borrower. We certainly don't want this loan to be cross-defaulting and cross-collateralizing some other debt. Because really what that's doing is it's expanding the universe of problems that you're going to have to deal with. And even if you have seniority and even if you have control and even if you have power over how to work through these, you're going to be in the position of having to solve their problems caused by some third-party project. So we are very strict in watching and protecting you on the cross-default, cross-collateral situations. We very often in these documents, however, recognize that the parties will have other relationships and that those relationships are separate and apart from this, and as long as they are not violating the terms of this subordination agreement in order to keep those relationships current, that we know that you're going to have other loans, other banking relationships with this customer, and that likely their investor is going to have other investment opportunities. So we acknowledge that, and for us, the clear line is we do not want to have any of that crossing over in that cross-default, cross-collateralization situation. I want to note a couple of things. There is some case law that has popped up. It was both pre-recession and has now come in post-recession. It imposes a little bit of a duty on the senior lender, and it can easily be summarized this way. One of the key items is if you go to the effort and have a subordination or intercreditor agreement, that agreement imposes upon the senior lender to provide notices and to keep the junior lender in the loop. And even if you try to disclaim those responsibilities, the assumption in the law is you do have an obligation to keep them in the loop. Now, you can have them waive their right to approval. You can have them waive their right to have any say in the matter, but you do have an obligation to keep them advised when you're making major changes. So we want you to be careful on that. Second is, the courts have taken a very narrow reading with the latest recession, as you'd expect, that if your subordination agreement is silent on an issue, they're going to read it in favor of the borrower, which very often coincides with the interests of the investor and not the interests of you, the senior lender. So that's why I'm taking the time to note all these different areas of concern, because we want to be able to say something about each of those, because silence is not golden here. Silence will be read against your best interests. In the old days, we used to do recognition letters instead of intercreditor agreements. I would say that those days are gone. We don't do recognition letters anymore. That used to be a stylistic thing that certain institutional investors preferred. I wouldn't. If you see somebody wanting to do a recognition letter, call me up. Even if we're not working on the deal, call me up, because I'm going to say, huh? Why? And they may have a business explanation. They may have some kind of limitation in their organizational docs that makes an express subordination agreement not possible, but they can enter into a tri-party recognition letter. Okay, we can work with that, but they better have a good explanation, because we expect a full intercreditor agreement.
Question?
Yes?
Would you typically have an event of default of the junior obligation create an event of default in our documents?
Yes. We typically have a default under their loan triggers a default under ours. We start off with the premise that a default of ours does not necessarily trigger a default on theirs. They have to have an independent source of default. Now, I will say that we have gotten into with some very sophisticated entities that as long as we put them in a box in terms of what they can do in terms of resolving their problems with our consent, we have agreed to concessions where our default does not trigger their default and vice versa. So if they have a default and they're working it out within our parameters, they have to give us notice. We may have certain consent rights, but as long as they're operating within the established rules, we will not automatically trigger a default. So that is something that I've seen change. And I think it provides all the protections that you want that we've talked about, and so I don't feel like we're giving away something by acknowledging that. But we start with the premise of their default triggers are. When we talk about mezzanine loans, when we talk about pledges of ownership interest, That's where you're going to assume the ownership and control of borrowers. Some things that I'm always very wary about when people look at this is, remember, if you're stepping into the shoes of your borrower, you're stepping into the shoes of their problems. And if they're in such a bad shape that you need to take over the company, they're probably going to be all kinds of hair all over this problem. There's going to be perhaps defaults under other obligations that need to be taken care of. And although in a typical LLC, you're going to have the protection or the insulation of not being personally liable, but you may find yourself being practically liable. Give you a good example. Help the company take over a Ritz-Carlton hotel. And as part of taking over the Ritz-Carlton hotel, we knew that they had labor disputes. We knew that they had problems with their liquor license. We knew that they had some safety concerns with their pools, etc. And we decided to take on the ownership. We were able to negotiate a window of time where we went to those parties and said, we can't fix it because we're selling it to a true operator, and please don't pursue any of your remedies under your agreements while we sell it to an operator. We bought ourselves time to sell it to an operator, a Marriott. The Marriott came in and took over and, in fact, assumed all those obligations and fixed all the problems. So we are wary of what you're stepping into, but we do have a track record of helping you deal with the practical problems. And the practical problems can very often be as serious as the legal ones. Because practically, if you can't run your hotel or run your business because of some issue, you got to get it fixed. If you take over an office building and the elevators are broken, you're going to lose tenants because they're going to say the property's not inhabitable, and they're going to walk, and they're going to probably have the legal right to walk. So practical problems are as important as legal problems, and we want to make sure that we do that. If we assume control and ownership of the entity, we typically want to make sure that if our borrower has failed, that the investor that may still be in the project steps up and guarantees completion if there's any construction or any operational issues. We want to make sure that if there are environmental concerns, that those are assumed, again, by the remaining investor partner. They may not have signed the original indemnity, but if we have to take over, we want them to assume those obligations. And I will say this, we closed a lot of commercial loans where either they're unsecured or we're taking a pledge of the membership interest. That is not a reason not to deal with environmental issues. Now, sometimes we get an environmental indemnity. Other times we built the hold harmless and environmental provisions into the loan agreement. But the bottom line is, if you are taking over a company that has real estate, you want to have protections that, A, they're going to be complying with the laws. You're going to have the right to inspect the property. If something goes wrong, you can bring a contractor on to fix it, and they're going to pay for it. So I had a conversation recently with a borrower where we were doing an unsecured line, and they had always used Laser Pro, and they were graduating up. The borrower was borrowing more money. We were going away from Laser Pro. In my loan agreement, I had a hazmat section. They kind of said, hey, do we need this? We're not taking real estate. And I explained what I just told you, and they said, oh my goodness, we really do need a hazmat relationship because this was a manufacturing plant. And there are all kinds of hazardous material problems that could have gone wrong, and we want to have those same protections for you, particularly if you end up taking over the company. We want to make sure somebody is standing behind the environmental condition of the property, and that very often may have to be the investor. In addition, if the investor is going to be assuming control or ownership of the borrower or staying in the borrower, we want to make sure that if they have any business plans or recommendations for change of management that are provided to them in their operating agreement, that we have approval rights. Because again, you've underwritten this business, the operation and the expertise of the business, and we want to make sure that it's probably the management is crappy. That's why the business has gone under. You want to make sure that whatever their new business plan is and whatever their new management plan is acceptable to you. So you get a second bite of the apple. In other words, when anybody's exercising rights down the road, whether it's you assuming control or whether it's the investor assuming control, we want to give you the right to re-underwrite that loan and to be able to get those same protections you would get for your original underwriting of a loan. And those are guarantee protections, environmental protections, and an understanding of the business plan and the management plan. Same things apply for membership or partnership rights. The last thing I'd want to say is there are occasions where you may be making a loan and there's a pre-existing mezzanine loan and maybe a pledge of an interest in the entity. And there are two ways to go about it. You could do an intercreditor agreement, but just as effective is in your document, you can build in what I call permitted transfer language. And what that is it has the holder of these interests acknowledge and agree that they can't effectively foreclose and take over control of your borrower unless they jump through all the hoops we've talked about. And we build that into the loan agreement as part of a permitted transfer. And if they don't do those things, then your due on sale clause applies. Their attempted control is deemed void and invalid, and you can foreclose on whatever your interests are and try to collect your debt. The purpose being is there are many ways to get these protections in there. And it doesn't always have to be in a separate piece of paper. And we can build a lot of this stuff into the loan agreement, either by putting in hazmat provisions, permitted transfer provisions, etc. Ground leases. I want to very quickly just go through the concept of ground leases because I want to be mindful of time. We've gone a little bit over, so Peter, I promise I will wrap up in the next 9 minutes. I will wrap up and keep you only 15 minutes late. The two things I want to say about ground leases is you'll hear the concept, is this a subordinated ground lease? That phrase means nothing. So just know that. If you have a ground lease and somebody says, is it a subordinated ground lease? The answer should be, how the heck should I know? We haven't met with the ground tenant yet. You subordinate a ground lease with a subordination agreement or what's known as a consent and estoppel agreement. And in that agreement, you provide that they're able to have their lien on the ground lease. You provide various protections for them. You provide protections for yourself. You want to make sure that the property income is coming to you. You want to make sure that if they take over control, all those things we talked about, permitted transfer, are going to be applicable. If they're going to step in, we want to make sure that we have a guarantor, somebody standing behind the environmental condition. We want to make sure that there's a business plan and a manager, etc. We build all of that in. The most important thing they're going to want, and they're going to trade the moon for this, is that they are vulnerable. A ground lease can be terminated automatically without recourse in a bankruptcy because it's considered an executory contract. So when you file for bankruptcy, your borrower can say, I'm not assuming that ground lease. That's off obviously devastating to the ground lease because that's their sole collateral. And it's probably devastating to you because it's probably not the best way to solve the problem. So the trade-off always is a provision where if the borrower exercises that termination right, we allow the ground lessor to enter into a new direct lease obligation, which has all the bells and whistles and protections that we've just talked about. And we allow them to protect that interest because we, again, want them to solve your problem. We don't want you to be in the position to end up with a piece of property that you have to go remarket and find a new ground tenant for. If you have a successful ground tenant, if they're not in default, if they're performing, and your borrower has just mismanaged affairs, you want to keep that relationship. And so we protect that relationship as much for your protection as for their protection. But I can guarantee you, by promising that to them, you can get just about anything else you want in that ground lease estoppel. So it's a very powerful tool. On foreclosure rights, really don't want to talk about this. We've already gone through it in terms of standstills, post-default relationships, on a ground lease, the termination issue, etc. I want to spend a little bit of time on SNDAs. And here's the thing that I want. Okay, this is number 2. I said if there's one thing you want to take away, it's that tri-party relationship, right? Here's the second thing I want you to take away. In an SNDA with a tenant, the least important word and the least important concept is the S, the subordination. Really, the entire gut of an SNDA are in the NDA portions, the non-disturbance and attornment. And that goes directly to the 3 relationships. And you'll see on this slide, on slide number 9, I talk about specifically what those 3 relationships are and what the key issues are that you need to preserve. Now, this is in the concept of a tenant signing an SNDA. These very same concepts apply to investor debt, to third-party mezzanine debt. All of these issues apply, but I've put it here in the context of the lease subordination. But if you're sitting there and wondering and looking at an SNDA, what is it that I have to protect? This is your cheat sheet. You have to protect on your relationship prior to default certain rights, the right to assign, the right to purchase, construction of improvements, how you're going to manage those. During default, notice and cure rights, attornment, hold harmless provisions for the lender, the not imposing liabilities on the lender for problems that they didn't create and couldn't have solved. And finally, after the default, you certainly want to be exempt from prior problems. Those remain personal issues for the prior landlord, which legally is appropriate. You want your liability limited to your interest in the asset. So we don't want them suing you for the bank's balance sheet. We want them to sue you for whatever income is coming off the property. And we want to limit them to that. They shouldn't have access to First Bank's balance sheet. They should have access to the balance sheet of that particular property. And finally, and this is a big, big deal, in these relationships, when you sell and move on, you want an express upfront release of any future liability. There's a very famous Bank of America case where Bank of America foreclosed on a piece of property. They then shifted title to a wholly owned B of A entity. That B of A entity then didn't take care of the roof. They didn't take care of the plumbing. They didn't take care of the parking lot. They basically managed the property as poorly as you possibly could, violating every lease provision and giving rights to liability to B of A in that instance. They then turned around and sold the property to a developer. The developer was very slow in getting these fixed, and the tenant was able to go back originally to B of A itself for the time it was on title, even though it was a momentary time on title. They were on title probably 5 minutes before they assigned it to their single asset entity. Doesn't matter. They were on title when those problems existed, and they knew about those problems. And the court ended up finding a judgment against B of A itself for $1.8 million to fix up that property. Now, it was a joint and several judgment with their single asset entity and with this new owner. The new owner didn't have the money. Certainly the single asset entity didn't have the money. So who was writing the check? B of A. We're going to protect you from that. We will always build in that pre-release, because the pre-releases are fully enforceable. But you got to get that in there. Otherwise, I can guarantee you, 3 years down the road, when they have a plumbing leak, if you were on title, they're going to sue you for it. And they may very well win. Talking a little bit about what we call ARNDAs. Those are assignment, recognition, non-disturbance, and attornment agreements. I'm going to turn over 1 minute to Jim Kousselis because we're running out of time. Jimmy, I know you have some thoughts on ARNDAs, so I want you to very quickly share those with us. I think we've lost Jimmy. So, here's what an ARNDA is. We use it in a variety of situations. You can have a piece of property collateral, and maybe you're not even loaning on the collateral. Maybe you're loaning on the business assets, right? But some other party has a purchase option for that property. And that property, of course, is essential to your business operations. There may be a tenant on the property or a subtenant on the property who has a right of first refusal if the property is going to be sold or subleased, or they might have a right of first refusal if there's going to be an expansion of the property, etc. Expansion rights, fixtures on liens, etc. When you find yourself, whether you're making a real estate secured loan or whether you're making a loan to a business that is dependent on their real estate operations, their plants, their factory, whatever, we do need to check title. We do need to look for these types of items, and to the extent that we find them, we want to have these tri-party relationships so that you don't wake up one morning and think that you have a lien on Folgers Coffee that is dependent on their Culver City plant, and somebody has come in and bought their Culver City plant, and now you're looking around saying, well, how am I going to be repaid? Because somebody else owns the plant, and you don't have any right to the proceeds necessarily. An ARNDA is a way that you can insinuate yourself into that relationship, have the right to be given notice, have right to have your loan paid off before they exercise the right, or to be able to receive the proceeds of any such sale so that you pay off your loan. In other words, we want to make sure that even though your collateral doesn't include the property may be essential to the operation and the value of your collateral. So that's where an ARNDA comes into place. We've talked a little bit about purchase option agreements, development restrictions. Here's a couple of things I will say about this. More and more we're finding when you do residential tract development, we're finding that you'll have a master developer, you'll have a large company like Lennar, like CalPERS, like Lycera, they'll buy the tract of property, and then they have a vision of how they want to have it developed, and they'll have a master development plan. And they're even willing to invest in marketing fees and different types of costs and expenses. Now, they expect to capture those when people build the homes and sell the homes. They intend to capture those monies back. In those instances, it's very common and very typical that we enter into intercreditor agreements with the developers. And we acknowledge their liens, we acknowledge their rights. And here's the number one thing I would say about this. We used to, in the old days, be successful in saying if we foreclosed, we wiped out all of these protections and rights. That doesn't really work anymore. It doesn't work because they're more sophisticated. They know that we're not going to own and develop the property. We're going to flip it to a real developer. And their expectation is a real developer knows how the game is played. And if they've been getting marketing benefits, they're expecting to pay for those, et cetera. Here's what we're looking to do for you as a bank. If you are, whether it's a commercial center, whether it's an office building or a complex of buildings, an industrial center, or a single-family home, if you have these types of ties by the master developer to your property, we want an agreement which, A, commits the master developer to us that they're going to fulfill their obligations, and number two, an agreement by them that if we end up owning the property, we're not assuming these obligations, and as long as we own the property, unless we take on the role of developer, we don't have any obligation to pay them at all for these obligations, but those obligations will spring back to life when a true developer party comes in, owns the property, and is taking over. And most developers are very knowledgeable, and they expect if they're buying foreclosed property that they're going to be buying it subject to these obligations, whether it's profit participations, whether it's marketing fees, whether it's rights of first refusal if you don't develop the property the right way. They understand they're going to take subject. So it's actually not as difficult in a negotiation as you'd expect it to be, but the important thing is we want to create this bubble around the bank that when you're exercising your rights and when you're on title, you're not going to be beholden to anybody, and that you're going to sell the property as quickly as you can, as efficiently as you can, and at that time, you walk away with your bubble still around you, and the new party steps into all of the problems and has to fix them. So that, to me, is the key thing, just to make a point there on that. Just some concluding thoughts. A true tri-party arrangement is always one where there's flexibility, there's predictability. As I've talked about, there are going to be competing tensions. What we're looking to do is give you the right to manage the process between the parties, the right to use your underwriting criteria to give approvals. We don't want you to be stuck giving pre-approvals to work out strategies. We want you to have the right to exercise your underwriting at the time to be able to approve workout proposals. And if you do end up with an asset, we don't want to put you in a position where A, you have to become an instant operator, and B, you're going to be assuming obligations, liabilities, whether legally or practically. We want to create that bubble around you, acknowledging that the new owner is going to have to address all of those. Does that affect marketability when you go to sell it? Well, sure, I'm sure it does. On the other hand, it's become so well understood in the industry that it is not having an appreciable marketing downturn. And so from our standpoint, we found out that it really isn't a negative in going out and being able to quickly resell the property and be able to get market prices. And we've seen this most recently with a company that we represent that took back a lot of raw land, commercial land, residential land, and they've been sitting on it for 5 to 7 years. And now that the market has come back, we've protected ourselves either with the city or the county and their development agreements. We've created that bubble, right? So you're not having to develop according to their rules. We've been able to get that postponed by getting the protections up front. We've been able to build in those protections vis-a-vis investors and other people involved. And what we found out is we've been able to go out and resell that property at or above the appraised value, meaning having this little bit of hair on the project that we're selling has not affected pricing at all. And so I don't want you to feel like we're proposing something that's going to put you in a compromised position, because the reality is it's not turning out that way. The market has become sophisticated enough that they understand what good lenders. Now, do you have community banks who give away everything? Sure you do. And do you have borrowers who will come to you who have been working with community banks and say, I've never had to deal with this before? That's where we can come in, and we can nicely help them understand that when they move up to a bank like First Bank, not only are they getting a much more sound and solid institution, but they're getting a much more involved partner that at the end of the day is going to create more opportunities for them to fix their problem and not put them into that toggle switch foreclose or not foreclose position. And that's our job, is to create those options for you and create the options for your borrower. And we're really good at explaining that to them. So if you find yourself in one of those discussions and you're trying to win a deal, you know you can just put us on the phone. We'll talk to them. We don't open up a billing matter. We don't start charging you for it. We want to see you get the business. But we'll spend that time and we'll explain it to them, and we'll walk through how many of these things, not all of them, but many of these things are as protective for them as they are for you. At that time, I think I'm done, and I've a little overstayed my welcome, Peter. So I turn it over to you to see if there's any questions, but that's the end of my program, because you next move into my series of slides where I give my white paper on dealing with bridge loans, unsecured loans, real estate secured loans, etc., and give you lots of checklist items that you can use as cheat sheets, and that's my intent, is to give you some cheat sheets. So, Peter, it's all yours.
Well, Ren, again, I appreciate your time and your attention for us, and if there are any questions out there, feel free to shoot me an email, and I can pass those on to Ren, and we can get those answered. I appreciate everybody else's time as well.
Well, thank you, and I do commit to you to whether you're sending the question to Peter, who relays it to me, or you send the question to me, I can guarantee you that I will respond to it promptly, and sometimes that's a phone call and sometimes it's an email, but I won't leave you hanging. I'll always give you an answer.
Thank you very much, Ren.
Thank you.